The broadcast is now starting. All attendees are in listen-only mode.
Hello and good afternoon, everyone, and thank you very much for clicking on and logging in to today's Insurance Law webinar presented by the Insurance Defense Group at Kelly Santini. This is the latest in our series of insurance law webinars, and we're glad so many of you could log on for today's talk. We have great representation not only from Ontario but also interest from across the country, so welcome if this is your first time attending a Kelly Santini webinar. My name is Keith Gallup. I'll do my best to moderate today and keep the technology running, and our topic today is Don't Slip Up on Slip and Falls, and our presenter is Mark Friedman, who is one of the partners in the Insurance Defense Group here at Kelly Santini. And Mark brings some unique perspectives to his role working with insurers, which he'll elaborate on shortly. Mark has almost 20 years experience in the insurance sector, and despite that, has never given a webinar before. So I promised him today will run smoothly, that the technology will work and the questions won't be too hard, but hopefully 1 out of 2 of those will be true. Mark will be talking for about 30 minutes, and then we'll reserve some time for questions towards the end. So by all means, as the presentation is taking place, please do send in, type in any questions that you have using the dialog box on your screen, and we'll reserve some time towards the end to address as many of those questions as we can. And finally, before I turn things over to Mark, just want to say at the conclusion of the webinar, as we log off, there'll be a very short 3-question survey just to give a chance for you to give us your feedback on the presentation and let us know what topics you'd like to see presented in the future and how we can continue to improve these webinars for you. Now, let me turn things over to our presenter, Mark Friedman.
Good afternoon, everyone. Thank you, Keith. As Keith alluded to, in terms of my background, I've had the good fortune of not only practicing law here at Kelly Santini for about 12 years, but the opportunity to sit in your seats. I have previously worked as a claims adjuster and then as a claims specialist at a national insurer, and taken what I learned working with that insurance company and dealing directly with plaintiffs and insureds into my role as counsel. What I plan on doing today is giving you, probably for some of you, or maybe a lot of you, some tips and some information with regard to assisting you in your investigation of slip and fall accidents, and at the same time provide you with the bare bones on the law under the Occupiers Liability Act, and maybe share a couple of stories in terms of dealing with slip and fall cases, which I hope will be of some assistance to you as you continue to deal with slip and fall cases in the future. First, you'll see the headings that I plan to address today, and you'll see that I have, under number 1 to number 8, addressed the issue of the plaintiff and contributory negligence. I'm looking at the 2 issues separately. First, initially, any case that you have with regard to a slip and fall case starts first and foremost with the plaintiff. And whether or not there was a slip and fall incident that in fact occurred, we need to look at who the plaintiff is. Taking a look at the age of the plaintiff in terms of what could have caused or contributed potentially to an injury based on the age of the individual, male, female. What is that individual's background by way of employment? Was he or she working at the time of the accident? And was he or she earning receiving disability benefits? You will want to obtain very early on as much background information as you can with regard to the injured party to help you assess not only the claim itself in terms of the value of the claim, but potentially the credibility of that individual in assessing the issue of liability. And you'll note that I've also raised the issue of education, and as well you need to always be aware of family law claimants in any slip and fall incident. With the report of the slip and fall incident, it's important that you obtain immediate contact with the plaintiff to obtain a detailed statement to address the issue of liability. As you're aware, with slip and fall incidents, there are occasions where you hear very early on after the fall by way of either the plaintiff directly or by way of your insured of the slip and fall incident. You may also not hear for some time about the incident, and typically in those cases you first receive notice from a lawyer. Even where counsel has been retained, if you can get out and meet with the plaintiff to obtain a statement by way of permission from that lawyer, that would obviously be of assistance to you in investigating liability. You're obviously at a disadvantage where you're dealing with plaintiff counsel who aren't prepared to allow the plaintiff available to you, and you're often left in a situation where you're not aware of who the plaintiff is and what the real facts are in relation to liability until you've retained counsel and gone through the discovery process. With respect to the other potential parties, you're looking at who are the potential defendants in a slip and fall lawsuit, and that typically starts with determining who is the occupier of the property where that slip and fall incident occurred. As you're all aware, the term occupier has been defined under the Occupiers Liability Act. The Occupiers Liability Act applies to different venues, including homes, shopping centers, offices, stadiums, schools. You'll see typically under most, if not all, cases that are commenced here in Ontario, the Occupiers Liability Act will apply in a slip and fall case. Under Section 1 of the Occupiers Liability Act, an occupier is defined as, first, a person who is in physical possession of the premises, and secondly, a person who has responsibility for and control over the condition of the premises or the activities that are carried on, or control over persons allowed to enter the premises. Given this definition, obviously not simply the owner of the property is exposed to potential liability. There may be more than one occupier in the defense of an action, and as I have found in the course of the years I've practiced, there could be up to 4 or 5 potential occupiers in a case. Typically, where you have a slip and fall case and it's reported to the insurer of the owner of the property, that party typically is then left to determine what other potential individuals or businesses may be determined to be an occupier and potentially responsible for the alleged injury sustained by the plaintiff. You'll typically want to have some dialogue with your own insured with regard to potential other defendants and potential discussions with the plaintiff's counsel or the plaintiff, him or herself, early on to ensure that when that lawsuit is commenced, or if it has been commenced, that the proper parties are named in the main action. If necessary, if the plaintiff's counsel is not prepared to add, for example, a snow removal company or a security company or an individual who had some responsibilities on the premises that may have given rise to liability, you may have no choice but to third party that individual or business or corporation into your action. As I've alluded to, the potential other occupiers that I have seen, and the list probably is not exhaustive, could include a tenant, that being a residential tenant of a premises that your insured owned, or a commercial premises of a premises owned by a commercial property owner. It could be a landlord of a property. It could be a security company that provides services surrounding inspection of a property. It could involve an actual cleaning company, for example, an office space, a commercial property, or a supermarket. It could involve a snow removal company, which is the most obvious case. And finally, a property manager who has had responsibilities delegated down from an owner of a property to oversee the indoor or outdoor maintenance of a property. Each of these, as I've just alluded to, each of these parties should be considered when you're initially investigating your claim and determine whether or not you wish to place one or all of these parties on notice of a potential claim. The earlier you get other potential parties involved, the better situation you'll be in potentially either addressing the issue of liability or eventually resolving the claim with or without representation. In addressing ownership, you need to make sure that we know who the actual owner is at the time of the alleged fall. You need to make sure that you speak to the named insured or representative of the insured at the time of the alleged fall to ensure that that person or company is properly identified. You may need to take a look at leases to properly identify the proper names of potential tenants that could be exposed. You'll want to determine who is responsible for and control of the condition of the premises. That's what defines who an occupier is under Section 1 of the Occupiers Liability Act. Sorry, I moved this along without letting Mr. Gallup know what cue we're supposed to see up. So I've moved ahead now to the location of the alleged fall. In your investigation, you need to attempt to get out and view the location where the alleged fall occurred. If you got a claim that's being advanced, whether in litigation already or earlier on, if you can meet with the plaintiff and or the plaintiff and counsel and go out and review the circumstances of the fall, you'll be in a much better position to assess the plaintiff's case and as well potentially your defense of the case. I myself have gone out in the last few years to meet with counsel and plaintiffs to identify locations of falls, particularly in cases where potentially there's one or where there's two or more occupiers potentially involved, where the location of the fall would assist in determining whether or not one or two or potentially three occupiers are actually necessary to the ongoing litigation. In an attempt to view the location of the fall with the plaintiff and getting a sense of the mechanics of that fall from the plaintiff, and then considering what is said at that moment in time and potentially reviewing information that is developed in your investigation at examinations for discovery by way of reviewing medical documentation. It could assist in the event there is a real credibility issue as to whether or not there in fact ever was a fall. I think that we've all had cases where we've raised questions with respect to the credibility of a plaintiff and whether or not a fall has in fact occurred. And certainly your first-hand attendance at a location with the plaintiff to get their version of what happened assists not only in determining whether there was a fall that occurred, but helps you in terms of dealing with your assessment of liability in the event that you're prepared to accept what happened. It's important to determine what time the fall occurred and the date of the fall. I've been faced with a couple of cases in the past couple of years, ironically dealing with the same contractor, where actions have been commenced against this contractor where it's been alleged in the statement of claim that the fall occurred on in or about January 2008, for example. In terms of defending such an action, that makes it very difficult for you to defend it in that you don't know the date and you don't know the time of the fall, which makes it difficult to deal with determining whether or not your insured could in fact have been providing services or had been acting reasonably on the day when the alleged fall occurred. What I have found in these two cases is that there was an issue of credibility with respect to a fall ever occurring, and where an alleged fall occurs and it has been pleaded that the fall occurred in or about a certain month, you should be probably raising your eyebrows as to whether a fall occurred and need to conduct some investigations with regard to the credibility of the fall ever occurring. What I have found in those cases is the medical documentation can be of assistance, particularly the records in relation to the immediate medical attention received after the fall. And if the medical records seem to suggest that the fall occurred 2 days earlier, your weather records and records you obtained from your insured suggest that there's potentially a condition that gave rise to a fall. In your meetings with the plaintiff and potentially the information that's obtained at examinations for discovery, you will get a better sense as to the credibility of whether or not a fall occurred on a specific date. It's important to locate or identify the time of the fall given the investigation that's required by you to determine whether or not your insured contractor or landlord acted reasonably in the circumstances. If the fall occurred at 10 p.m. on January 20th, 2011, and the records that you have obtained from your insured contractor identify services being provided in the hour or two prior to the occurrence of the fall, obviously that is of assistance to you. I've also found over the years that the time of the occurrence of the fall can move on the basis of either poor memory, selective memory, or desired memory of a plaintiff to ensure that the time of the fall can fit in with potentially putting some liability on the defendant. With respect to your investigation, in terms of identifying where the fall occurred, as I've indicated before, going out and determine the location of the fall can assist in putting liability on one occupier as opposed to another. For example, a landlord could be responsible for a sidewalk, while a contractor is responsible for the parking lot. If it's identified very early on that the fall occurred on the sidewalk, it's not necessary to bring a contractor into an action where you know that that contractor has no responsibility. Of course, in cases where you're not receiving a definitive answer in terms of where the fall occurred and you need additional information that's not being provided by way of either the plaintiff or another party, you may have no choice but to bring along additional potential occupiers to at least the stage of examinations for discovery to determine who the proper party should be responding to such an action. In assessing the location of the incident, you're going to want to take a look at the actual location, whether you're dealing with a parking lot or sidewalk or the floor of a commercial property or steps and stairs leading into a commercial premises. You'll want to determine, say for example, from the perspective of the independent contractor, was, for example, poor drainage or defective eavesdropping causing or contributing to a condition that led to ice formation and the potential fall. You'll want to know whether or not what type of condition was maintained within the property. Is there debris everywhere when you attended at the premises? What type of condition was it when you visited the premises? I've been faced with cases where the plaintiff has produced photographs on end of the condition of a parking lot both before and after an incident occurring. Obviously an eyebrow gets raised when you see that a plaintiff is taking photographs of a parking lot before an alleged fall. But at the same time, those photographs with respect to the condition on the day of the fall, and the days after the fall, and the weeks after the fall, can also be of assistance to a plaintiff in establishing that the condition of the property on the day of the fall, despite whatever records could be produced, may not be accepted, or in the alternative can result in establishing that some concern can be raised with regard to the actions being fulfilled by an independent contractor. In your inspection of the location of the alleged fall, you're not only looking at whether or not the slip and fall occurred because of the banana or ice or snow formation, but potentially could the fall have occurred as a result of poor design, for example, in the construction of the set of stairs, whether it be poor design in terms of no railings being available or potentially an improper material used for the steps themselves. I also make reference in the note there of the general condition of the pavement. There has been cases decided in favor of a plaintiff where, while the defendant contractor has established that they have provided services on the day of the incident, a judge has accepted liability where the condition of the premises is so poor that they're prepared to accept that that condition of the pavement caused or contributed to a slip and fall. In terms of your investigation and your visit to the location, there are certain activities that you can complete to assist you in addressing the issue of liability. In the event that you're dealing with a design issue or potential issue involving drainage or eavesdrops, you may want to consider obtaining a survey of the premises. In cases where available, if you can obtain video surveillance of the day or night of the incident to determine whether or not a slip and fall in fact occurred, certainly make inquiries with your insured for such video surveillance. Certainly it's been my experience that in most cases such video surveillance is not available, but certainly when you're dealing with cases involving businesses such as Tim Hortons or McDonald's or major shopping centers, such video surveillance can be of assistance to you. in not only establishing potentially whether or not a fall in fact occurred or the mechanics of the fall, but whether or not your insured was acting proactively in dealing with any potential danger or acting simply in terms of inspections of the property in advance of the occurrence of that fall. Where necessary in dealing with design issues, you may want to obtain measurements of, for example, the stairs. You will want to take photographs of the location of the fall. You'll want to obtain weather records in terms of the weather conditions on the day of the incident and in the days prior to the incident, and if possible, obtain hourly reports from Environment Canada to assist you in determining the actual weather conditions in the hours before an incident and the days before. You'll want to obtain documentation from your own insured dealing with not only their reports and logbooks addressing the work done, but any inspections done. You'll want to determine identifications of any other potential parties involved in your site visit. You'll want to see if lighting had anything to do with the potential fall, and you'll want to determine whether or not in the event that there was a danger that was present, was it detected, and if it was detected, were steps taken to let attendees of a commercial premises, for example, such as a supermarket, know of the apparent danger. You'll also, in your investigation, want to determine whether or not there are any prior incidents that are similar in nature, which could give you some concern in defending the matter, whether it's on behalf of a landlord, tenant, or independent contractor. You'll want to as well address whether or not there were any witnesses in terms of the fall, and potentially any witnesses dealing with the maintenance of the property, and as well witnesses dealing with the injuries. Typically, we obtain witness statements for the purposes of anyone who actually witnesses a fall, slip and fall incident. These individuals will provide you information in terms of what they observed with respect to the fall, what they observed with respect to the condition of the premises or area of the fall occurred. In addition, in terms of witnesses, you could obtain witness statements from individuals who could be of assistance in addressing the maintenance program that was in effect on the day of the incident. For example, if an accident occurred in a parking lot and you have information to suggest that the independent contractor was out providing snow removal services, it could be beneficiary in the event that people have actual recollection of the day and incident of obtaining statements from those individuals to confirm that your independent contractor was out providing such services, for example, throughout the course of the day, and observed the independent contractor providing salt or ice control services. The witness statements that you obtain will assist you in addressing the issue of contributory negligence. The witness statements will in all likelihood assist you in addressing the issue of the injuries. We've all been faced with cases in slip and fall situations where we have had actual breaks occur. When I say that, I mean a fractured elbow or a fractured ankle. There are also cases that you are faced with where individuals slip and fall, get up, and get on with their day, exhibiting signs of injuries. And it's important in attempting to obtain statements from witnesses, not only addressing the issue of liability, but what observations were made of that individual at the scene of the incident or in the days after if there's any further contact. It's important in terms of your investigation to try and, as I've indicated earlier, to conduct that investigation as early as you can. Obviously, as the insurer of the occupier, you're in the hands of either an occupier who's notified you of the slip and fall incident, hopefully sooner than later, or the plaintiff pursuing his or her claim against your occupier insured. And only at that point in time are you in the position to investigate the claim. Often you can be behind the ball in addressing the issue of liability, and you're left in the hands of what transpires at an examination for discovery. I've also raised the issue of violations of a building code in your investigation. Obviously, dealing with issues of the stairs and potential railings and potential defaults that may cause or contribute to a slip and fall incident in the actual design of the property, you'll want to determine whether or not there's a violation of a building code. And in doing that, you may wish to retain the services of an expert to do a site visit with you to provide his or her analysis as to whether or not there has been a building code violation. There are obviously other experts that can be retained to assist with respect to dealing with slip and fall incidents, as I've identified on this card. With respect to the building code violations, I'd suggest to you, based on a recent case, that even where you have a design issue, this does not necessarily mean there will be a liability on the occupier responsible for that design issue. I had a recent case where the design of a set of stairs was brought into issue in terms of the length of the steps potentially affecting how the plaintiff walked down a series of stairs, suggesting that she may have overstepped onto a third step from a second step, which caused or contributed to the fall. The plaintiff formulated this opinion on the basis of an expert opinion that was obtained after the examinations for discovery. I can tell you that prior to the examinations for discovery, my client, one of the insurers, had an expert go out and take a look at the design of this set of stairs and did determine this defect. I was in fact retained by the tenant, and this defect would have affected the potential liability of the owner of the property. In this case, I wish to pursue whether or not there would be potential liability against the owner based on the evidence of the plaintiff at her examination for discovery. As it turns out, her evidence was positive for the owner of the property in that her evidence in terms of how she walked down the steps did not assist the plaintiff in his argument to suggest that the design of the steps had anything to do, or the defect in the design of the steps had anything to do with her slip and fall. In this case, it was simply just an accident. So it's important to recognize that while a building code violation can be of assistance in placing liability on a co-defendant, or a recognition on your end that you potentially could be exposed because of the building code, you still have to recognize that you need to hear the evidence of the plaintiff by way of either that statement very early on or the evidence under oath and examinations for discovery as to whether that building code violation actually caused or contributed to the occurrence of the fall. Experts can help establish a standard of care. They can also establish whether there's a breach of that standard of care. In terms of the standard of care, what we're looking at is under Section 3 of the Occupiers Liability Act, the general duty owed by an occupier to those persons entering the premises. And that duty is essentially requires one take reasonable care to see that persons and property on the premises is reasonably safe from foreseeable harm. That duty is not absolute, and occupiers are not insurers for any damages suffered by persons entering the premises. Their responsibility is to take such care in the circumstances of the case which is reasonable. The question is, what is reasonable care? In determining what is reasonable, you need to look at the facts of each case. You need to look at the circumstances in determining if the actions of the occupier are reasonable. What's determined to look at whether the actions were reasonable, in terms of the occupier and owner with possession, you want to take a look at the system that was in place, the system of inspection, system of policies for repair. Were these systems reasonable? If the system was in place, was it followed? If not followed, you have a breach of care. Certainly, most cases are won and lost as to whether or not the occupier or independent contractor met this standard of care. It's very important that once we take a look at what's been obtained in that investigation I discussed, that you then apply what you determined in your investigation or the evidence you obtain at examinations for discovery to determine whether or not there has been a breach of that care. What you'll find is that potentially what is reasonable can depend on where the loss occurred. The duty may be seen as potentially greater based on an increase in the nature of the risks, and as indicated, as I've indicated, for examples, there could be a greater duty where the pattern of activity is greater, such as at a supermarket, sports event, a senior residence, or in a construction site. The factors in determine whether an occupier has acted reasonably. As I've indicated before, was the cleaning and maintenance system regular or reasonable? Was it in place and reasonable? If there are any employees involved, were they trained to deal with the maintenance detection of danger and removing the danger? Was there a warning system in place where a hazard had been identified? You'll want to look again at the lighting or the design. With respect to the issue of addressing the responsibility of other occupiers, such as an independent contractor, we need to look at the involvement of the owner of a property in retaining an independent contractor and the reliance of the owner on the contractor. Under Section 6 of the Occupiers Liability Act, an owner-occupier of the premises is afforded the opportunity to argue liability falls on a third-party contractor. This section is relied upon by an occupier to argue liability against independent contractors. Under this section, the damage must be caused by the negligence of the independent contractor employed by an occupier. One must look at the duties in the contract to determine if the contractor in fact owed a duty alleged to be breached. For example, was the independent contractor in fact retained to provide the services where the alleged negligence occurred? An occupier must have acted reasonably in entrusting the independent contractor. There must be an adequate system of instruction, maintenance, and monitoring in place. The owner must have acted reasonably in the circumstances and must satisfy that the contractor was competent and the work was done properly. A mere assignment of the responsibilities is not enough. As the occupier, you must ensure that the property is maintained properly and must supervise the work and inspect it. In terms of addressing liability as between an owner and the independent contractor, you'll want to take a look at that contract to see who's responsible for what, who's responsible for snow removal services, at what level of snow is such services provided, who's responsible for ice control services, under what circumstances are those services provided, what product is to be used in providing those services, was that product in fact used, was there an inspection requirement placed upon the independent contractor, and if so, did they keep such records? If no such inspection requirement was placed upon the independent contractor, what inspections were completed by the owner? You'll want to determine whether or not, as I've indicated earlier, were logs kept for the work done. You'll want to see what type of detail there is for such work that was completed. You need to take a look at those contractual terms and determine whether or not your independent contractor met those contractual terms. You'll need to take a look at those contracts to see whether or not there are any insurance provisions or indemnity provisions that can be relied upon by either the independent contractor or the owner to attribute responsibility for defending and indemnifying in the slip and fall case. I've also looked at three potential defenses that can be looked at in terms of dealing with these cases. The Occupiers Liability Act first has Section 4 of the Act, which sets out a provision that allows entrants to willingly assume a risk when entering onto the property. In such a case, the occupier only owes a duty to the person to not create a danger with the deliberate attempt of doing harm or damage to the person, and to not act with reckless disregard for the presence of the person. Persons who have entered onto a property with the deliberate intention to commit a criminal act are deemed to have willingly assumed all risks and is subject to this lower level of care. This lower level of care also applies where you're dealing with a trespasser, and as well individuals who are attending on rural properties or other types of properties for the purposes of recreational activity and have not paid an entrance fee. If successfully argued that someone has assumed a risk, potentially a plaintiff will cover nothing. This is an absolute defense in an occupier's liability claim. Given that to be the case, judges are typically reluctant to endorse this defense as it negates the claim of a plaintiff. However, it may be used as a good negotiating tool in terms of defending such claims. Another potential defense that you can rely upon and determine very early on is to determine whether or not the slip and fall incident involved a Schedule I employee sustaining an injury as a result of a negligence of another Schedule I employee. Under those circumstances, there's no right to sue in tort. For example, potentially if you have a courier delivery person who's considered a Schedule I employee who sustains his or her injuries while attending at the commercial premises of another Schedule I employee, potentially you may be able to negate such a claim. Finally, in defending slip and fall type cases, we have the argument of contributory negligence, not contributory negligence. As you're aware, under the argument of contributory negligence, what we're looking at is the determination whether the plaintiff's acts or omissions caused or contributed to his or her injuries. And where a court finds that the plaintiff was contributory negligent, the plaintiff's damages will be reduced in accordance with the plaintiff's respective contribution to the occurrence of the slip and fall. I think that you're probably all aware of the potential arguments that can be made on contributory negligence, as I've indicated on this slide. The most common being, of course, whether or not a person was keeping proper footwear, whether they were carrying anything that caused or contributed to the fall, potentially eyewear, walking or running, as opposed to walking where it was deemed appropriate. Running instead of walking where it's deemed appropriate. I've raised potentially a defense of a medical condition, that being a condition that caused or contributed to someone's fall, that situation involving someone who has a disability. And I make reference to Mitch's case, and that would be my partner Mitch Kitagawa, who had a recent case involving a slip and fall incident on a municipal sidewalk involving an individual with a disability, where Justice Workington accepted that municipal sidewalks should be safe and universally acceptable and should be capable of accommodating all users, including those with mobility and visually impaired disabilities. This protects, in my opinion, not only potentially individuals who are disabled, but those potentially affected by age somewhere down the road, particularly in a case involving a municipality. There is no magic formula, as I point out, to assessing contributory negligence. Often numbers are provided to you in opinions on contributory negligence. It can be in a wide range depending on the facts and circumstances. In summary, I'd like to thank you for sitting in today to listen to me discuss the issues in terms of dealing with investigations of slip and fall cases, and what from my perspective is not necessarily needed, but what you could use or look at in investigating your slip and fall cases. I hope that I've assisted you in terms of determining what potential parties could be involved in a slip and fall cases, what you need to look at to determine once you've conducted your investigation or discovery has been completed, whether or not the standard of care has been met, and finally, what potential defenses can be raised. Thank you very much.
Thank you, Mark. And I think Mark, in his attempt to avoid any hard questions that might come in, has run us right up to 1 o'clock. And we do want to thank everyone for joining in today. We will stick around and answer a few of the questions that have come in, but if you do have to go, we understand, and we'll certainly do our best to get back to you directly with any questions that you might have. So thank you to everyone if you are logging off now, and if you do have time to stick around to hear a few of the questions and answers, delighted if you can. So Mark, we have a few questions that have come in. How effective are sweep logs where contradicting witness statements exist? Examples, a condition of a floor.
In terms of addressing that question, certainly whatever documentary evidence you have to support, for example, in a slip and fall case in a supermarket, will assist you in defending an action. The reality is that the logs are going to say what the logs say. The difficulty you have with sweep logs is they're contemporaneous with what happened on the day of the incident. They indicate that a sweeping was done, for example, at 9 a.m. The difficulty you have is there's always going to be a time gap between when that sweeping was done at 9 a.m. and when the incident occurred at 11:14 a.m. The logs establish that the work was done and that an inspection was done in the time period prior to the occurrence of the incident. In terms of contradicting witness statements, the reality is that witness statement that you're referring to probably indicates something to the effect of Johnny slipped and fell on the Coke that had fallen in aisle 3. Those sweep logs will assist you in establishing whether or not the supermarket was reasonable in its inspection and whether or not they were acting in a timely manner prior to the occurrence of that Coke bottle falling and leaving Coke on the ground. I think at the end of the day, do the logs win over the contradicting witness statement? Not necessarily, but certainly the sweep logs will assist you in defending an action in the event that work is being completed in accordance with those sweep logs in a time period, hopefully shortly before the occurrence of the fall.
Thank you, Mark. Another question has come in. What discount can be applied to an award for the plaintiff wearing improper footwear at the time?
I don't really want to put a number on it. I think at the end of the day, you could probably, depending on, every case is different. Certainly if there's improper footwear and the fall occurred simply because of the footwear, the percentage is going to be higher. Where there's other factors that could have caused or contributed to the occurrence of the fall, what that individual was wearing may not have been as significant in terms of the occurrence of the slip and fall incident. If you're going to ask me to put a number on improper footwear, I would probably say something to the effect of up to 25%. I may be conservative on that number. Some would suggest higher. Some may suggest lower. Again, the problem with slip and fall cases is they're all so fact specific. I don't think there's a set percentage I can give you. And I think I alluded to that in terms of this, dealing with the issue of contributory negligence.
Okay, thanks, Mark. Is it okay to ask for a legible, colored photocopy of the plaintiff's ID as well as transcribed medical clinical notes of the plaintiff?
Well, I'm of the opinion you can ask for anything. I don't know if you will necessarily get it. In terms of the legible, colored photocopy of the ID, I think you're dealing on a case-by-case basis with the individual. I don't think there's anything wrong with asking it. I'm not sure in all circumstances it's absolutely necessary. I think in the second half of your question, dealing with the medical clinical notes, in all likelihood when you obtain those medical clinical notes, you're going to be provided with some information that properly identifies that individual. In terms of the transcription of clinical notes and records, as we all know, doctors don't write clinical notes that are easy to read. Certainly if you're prepared to pay for the transcription of those records, I've requested records on numerous occasions for them to be transcribed. In fact, I've had occasion where I wish I could ask for the transcription of some adjuster's records or my own records.
Okay, let's take two more questions. We won't have time to get to everyone's today, but we will take two more and then do our best to get back to everyone. If an organization that rents a facility for an event, are they to consider an occupier?
Definitely. Certainly in the circumstances of a situation where I have recently dealt with, where an incident occurred, not a slip and fall incident, but an incident occurred at a local stadium here where not only the owner of the property, that being the city, was sued, but so was the company that was responsible for operating the stadium. And from there, also the properly identified party who ran the event where the alleged event occurred was sued. In addition, the security company that was responsible for the event was sued. And in addition, in those circumstances, so was also the company that provided the alcohol that may have fueled the situation that gave rise to that lawsuit.
All right, and we're just going through the logs to take one more question. In terms of elderly or handicapped, are they exempt from contributory negligence?
No, they're not. They're not exempt from contributory negligence. I will say this: it's certainly more difficult to, well, it's not more difficult to establish the contributory negligence. Certainly, someone who's elderly or handicapped could have caused or contributed to the occurrence of the loss. I think, though, you've got to look through the forest on cases dealing with people who are elderly and or handicapped and recognize that somewhere down the road when you're dealing with the issue of liability, the fact that they're elderly and or handicapped will likely be looked upon favorably by a trier of fact, whether it's a judge or jury, whether you're dealing with this at a mediation stage, a pre-trial, or trial. You may have the best case going for you in terms of dealing with an argument of contributory negligence, dealing with someone who's elderly and handicapped, whether you're dealing with a slip and fall case or motor vehicle accident litigation, but certainly someone who's elderly or handicapped is likely going to garner some sympathy. And it goes back to my initial comments in dealing with the plaintiff, him or herself, is from day one of you dealing with your claim, you've got to recognize who your plaintiff is and whether or not he or she is going to garner sympathy and be a credible witness. And that potentially is what makes decisions of dealing with issues on damages and liability even when you think you've got a good case.
All right. Well, that seems like a good place to wrap up. Mark, thank you very much for talking to us today about slip and falls. Thank you to everyone who's logged in today and for all your questions that you've submitted. This webinar and all our past webinars, this webinar will be posted up on the Kelly Santini YouTube channel, and all our past insurance law webinars can be found up there as well. A number of you have asked for a copy of the slides, and we'd be happy to send those to you. If anybody else out there listening would like a copy, please just drop Mark an email, and he'll happily send you off a copy. Our next webinar is in the planning stages right now, and it should be taking place in late January 2014, when we'll take a look at some of the case law that came out of 2012 and some of the interesting cases that occurred and what their implications are. And finally, as we log off, please do take a moment to answer that very short survey that you'll see that lets us know how we did today, and most importantly, how we can improve future webinars and what topics you would like to hear. Mark, thank you again, and thank you, everyone. Have a great rest of the day.